All right, we are beginning the lecture for week 2, and that goes along with the class notes that I gave you that are entitled The Supreme Court is Not Always Your Friend. Um, what I wanted to do in this section, before we actually started getting into specific topics about the court and different things that it's done in the law that affect society over the years, I wanted to really talk a little bit about the history of the court, different cases it's been involved in, and the way that we look at it today versus the way the court has been looked at in the past. Over the last 60 years or so, the court has very much championed civil rights, both on the civil side in terms of undoing a lot of the segregation laws and the racist laws that had existed for a good part of the century before that. And it has also caused a revolution in terms of criminal rights, in terms of protecting people's rights when they are accused of a crime. If you think of things like the Miranda warning that everybody's seen on TV and has heard about, and the right to an attorney, different things like that, much of that came about through the actions of the Supreme Court over the last 50 or 60 years. So people today tend to look at the court fairly benevolently. They have a fairly high sense of the court's ability, and even on issues that are often very controversial, when the court comes down with a decision, there will be discussion and there may be arguments back and forth, but generally people accept the fact that it is the Supreme Court, that usually it makes good decisions, and that therefore we will honor what they say and we'll go along with it. We may work to change some of their decisions through legislation or constitutional amendments, but the court is generally held in respect. That has not always been true, and there was good reason why it wasn't true in other parts of our history. And so I really want to get that kind of implanted in your minds as we go through the different subjects we're going to cover in the rest of the course, knowing that, particularly in the times that we're in now, decisions the court is making are getting more and more controversial. The people in the country are very much divided at this point in time, so you have 2 or 3 or sometimes 4 factions involved in any one particular issue. And I think we're moving into a period where just because the court comes up with an answer to a question, that may not be sufficient as we go forward for people to say, all right, well, that's it, the court has decided, we're done. There's certainly, as we go forward, there's been some discussion about changing the court, about adding judges to the court, about changing the rules in the Senate, where the senators have to approve any judge that a president wants to nominate and place upon the court. So we're reaching a point in time where, again, what the court is doing and will do in the next few years is becoming more contentious, and the court runs a great risk, if they don't handle this correctly, of losing the respect that it now has among the people and it has among Americans. All right. There are really 2 threads that run through constitutional history, and they're things that have been there from the very beginning. They still exist today. As a matter of fact, they're being debated with renewed vigor and intensity today. And they are basically this. Number one is the whole issue of human slavery, and particularly as it was legalized and enforced and done in the British colonies and then in the American states. It was human slavery based on racial distinction. So where you basically had one race enslaving another race. The other question that has been ongoing since before the Constitution was enacted, was written in partially into the Constitution, and today is still alive and full of all kinds of questions and debate, is the economic system that we have. The Constitution had some very clear ideas about what should happen in terms of economics, and it was very much an economic document as well as a political document telling us how to set up the government. By virtue of the fact that the federal government could raise taxes, by virtue of the spending powers given to Congress, by virtue of the control of various federal bureaucracies and the military given to the president, the economics of life would come into play from the very first moment the Constitution was adopted, and again, they continue up to this day. Um, the writers of the Constitution were very much aware of the issue of slavery. The Great Britain, from whom they had broken away, had already begun to take steps to end slavery in their colonies, particularly in their colonies in the Caribbean. And by the time the Constitution was adopted, an abolitionist movement had developed in the North. A number of the northern states already had abolished slavery, and there was agitation beginning among Northerners to undo and get rid of what they saw as this horrible institution. The Southerners, on the other hand, saw slavery as necessary for their economy, necessary to preserve their way of life, and they did not want the system to change. They wanted to be guaranteed that the North would not impose its ideas and its ideals on the South. So when the Constitution was first written, there's a lot of ambiguity about this whole situation. Clearly, the Northern delegates did not like the idea of slavery continuing, but had they made any attempts to prohibit it, the Southern states would not have joined the Union, they would not have ratified the Constitution, they would have gone on their own way, and that would have really defeated the whole purpose for writing a Constitution. The bottom line of which was to try and somehow unite these 13 little independent states into a country that could defend and protect and economically support itself. But even though they allowed slavery to continue, there were issues that came up from the very moment of the Constitution's drafting in Philadelphia. The northern states, while they agreed to allow slavery to continue, they made it very clear that they wanted the importation of slaves from Africa and other parts of the world to stop. And they wrote into the Constitution that once it was adopted, there would only be a certain period of years where slaves could continue to be brought in from other countries, and after that it would be forbidden. When it came time to set up the Congress, there was a great debate as to how should we do this, were representatives to be sent with each state having a certain number, an equal number of representatives, or would somehow the population, as certain states like Virginia and Pennsylvania and New York had far greater populations than the other states, would the population somehow come into play? In order to keep the convention from collapsing over that issue, they came up with a Connecticut Compromise, called so because the delegates from Connecticut, drinking one night in a bar, came up with this idea, and it became the cornerstone of the setting up of the Congress. They divided the Congress into two chambers, a Senate where every state has 2 equal votes, and the House of Representatives where the number of representatives is determined by how many people reside in the state. Well, again, the Southerners felt they would be at a disadvantage, and they wanted the slaves to be counted as people for population in terms of picking representatives. The Northerners would not hear of it. They said, no, you're calling these people chattel, you're calling them property of yours, your property does not have the right to vote. We are not going to allow this. And again, to keep the whole thing from unraveling, they came up with a 3/5 solution, so that slaves were counted as 3/5 of a person in terms of the census, in terms of determining how many representatives would be allowed in Congress from each of the southern states. The reality is that all the Constitution did was to kind of, with glue and paper and spit, hold things together for a while, and tension between the North and the South over the issue of slavery began to grow, and of course it will culminate in the Civil War, and which is still the greatest, most destructive, deadliest war we have ever fought as a nation. Upwards of 700,000 people, civilians and military, died in the war, and it left the Southern economy in ruins. And still the issue of what happens now that the slaves have been freed and that their slavery no longer exists. What happens to these people? How do we deal with them? How do we bring them into the mainstream of society? And as you can see from the spring and summer we've been having, these issues are not resolved to our day. The Constitution was an economic document as well as a political document. Our revolution was very different from either the French Revolution or the Russian Revolution, the Chinese Revolution, the Cambodian communist takeover, or the Vietnamese communist takeover of that country. Those revolutions attempted to restructure the society, to restructure the economy, to undo the disparities between rich and poor, to come to some type of terms of dealing with ownership of property and to place limits upon that. The American Revolution did none of those things. The basic issue was they did not want to be part of Britain anymore. They wanted to be free from the taxation and from the economic controls of Britain. And that once England was defeated and sent on its way, very little in terms of the culture, the society, or particularly the economics of the colonies changed. The system remained the same. The legal system remained the same. The social customs and mores remained the same. And certainly property rights were upheld and respected. And the economic system that existed before changed somewhat because they were no longer part of the British Empire, and initially they were excluded from trading with the British Empire and had to find new trade routes and new countries and people to deal with. But as you can see by walking down Benefit Street in Providence and looking at the great mansions that were built by the merchants in the post-colonial period, they were fairly successful at that. They learned how to do that quickly, and very little of the underlying economy changed. You had basically your farmers in the north and your merchants, your sea captains, you had your plantation owners and plantation economy in the south, and you had a large growing wilderness where people went to trap fur, to cut down timber, to open up new land for agriculture, so that if no one told you that a revolution had taken place, just by looking at the economy of the states after Britain had left, even a number of years after they had left, by looking at the society, you would not have guessed that this dramatic change had taken place. The Constitution does not tell us what economic system we are supposed to have. Again, very much like English law became the law of the country, common law was accepted because that's just what had happened, and this revolution did not change the underlying structure of the law of society. The same thing with the economy. It was almost presumed that the economy would follow along a certain path, and the Constitution, by and large, left that alone with some changes. It certainly put in requirements that it made bankruptcy a national issue so that a debtor couldn't run away from their debts in one state by going to another state. It forbade tariffs and control of the movement of goods between states, and provided for Congress to begin the building of a postal system and the building of roads and canals and other types of things to bind the country together. Matter of fact, many of you are probably aware of the play Hamilton, the Broadway show that has become fabulously successful in the last few years. Hamilton was a great proponent of placing certain economic power in the hands of the federal government to help build the American economy into something that would be powerful and wealthy and of a benefit to as many people as possible. The Constitution does not tell us whether we should have a capitalist system, a communist system, or a socialist system. Those terms, as we know them today, really would not have made any sense to the drafters of the Constitution. However, the one thing that they were very concerned about was the protection of private property rights. And they wrote into the Constitution a number of things to ensure that private property rights could not be infringed upon by government, and they guaranteed the right of contract and the sanctity of contract so that property rights between individuals would have some basis in law and be controlled by some hopefully lawful and orderly process. And many people would argue, many historians and constitutional scholars do argue, that by placing such an emphasis on private property, which is also the basis of capitalism, that the Constitution kind of de facto, without calling it the preferred form, certainly gives a great benefit to anybody of a capitalist mindset. It certainly gives great protection to private property rights and to through patents and trademarks, which again were given to the federal government to control, gives rights to writers and entrepreneurs and the builders of industries, and basically left that to the people and left that in a system that today most people would call favoring capitalism, not socialism, and certainly not communism, where communism is that the government owns all property and private individuals have very few property rights. Um, Again, if you look at what's going on in the political campaigns for the last 4 or 5 years, the whole issue of socialism versus capitalism, issues of wealth disparity, issues of taxation of the rich versus taxation of the poor, those are all still with us. For periods of time, they will quiet down, then they come up again, and certainly we're in a period of time where people are beginning to question that, and certainly there seems to be a move among certain politicians towards favoring socialism, towards moving towards a system where the government has far more control over property and the means of production than it presently has. Some of those things are going to be left to be answered by you folks as you become older and come into power. But again, these issues were there at the founding, at the writing and enactment of the Constitution. They are still with us today. A third strain, a third type of idea that has really developed only since the late 1900s and came to full fruition in the only came into being in the late 1800s and only came into fruition in the 1900s, is the idea of the right to privacy. The word privacy does not appear in the Constitution. When we talk about privacy today, the writers of the Constitution would have been somewhat dumbfounded as what we consider to be privacy, as they did not really understand the term in the same way that we look at it today. About the only thing that the Constitution comes close to in terms of talking about privacy is in the Fourth Amendment in the Bill of Rights, where they did put in language saying that before a person's home, papers, office, barn, before the enclosed area of their property could be entered upon or seized by government officials, that there had to be a warrant based upon probable cause that a crime had been or was being committed on that area or with that property, and that otherwise people were to be left alone in their property, their houses, their buildings, their personal effects, their papers. But that's the closest that they got to any concept of a right to privacy. Then in the late 1800s comes along Louis Brandeis, who would go on to be a rather brilliant legal attorney, scholar, and judge, and ended his career as a Supreme Court justice. As a student at Harvard, he and another student wrote an article in the Harvard Law Review in the late 1890s talking about the idea of a right to privacy and how, using principles from the common law, the courts could embark upon finding that a right to privacy existed. They could use common law principles to define it, and that they could carve out this idea that we all have this sphere, this area that we can keep the government out of and the other people out of to the extent that we choose. This becomes very important as we went along in the 1900s and the 20th century, for this right to privacy becomes the basis for the right to use contraceptives, the right to determine who you will marry, the right to an abortion, and as we go forward now, it also is very much part of the whole courts dealing with rights of same-sex couples and of transgendered people. So the right to privacy was not an issue when the Constitution was founded, but over the last 120 years has become the third kind of rail in our constitutional reality. All right, we'll take a break for a second. Okay, in the second part of this lecture, I want to go over some of the cases that have come down the road over the centuries that, number one, show us the basis of the court's power, and again, number two, talk about that idea that the court didn't always make good or correct decisions, and that some of the decisions made by the court over the years are almost despicable in terms of the way we think today and in terms of the way we look at things today. Beginning very early on, the Constitution was only enacted in 1789. In 1803, the court heard a case called Marbury versus Madison. And the basic reality of what was going on in that case is that there was a presidential election. It was a very heated and controversial election, and the president of one party was defeated, and the president of the other party was now coming to power. Again, same themes as go on today. And in this situation, at the very last minute, the outgoing president, the lame duck president, appointed a whole number of judges, of notary publics, of magistrates, of various federal officials, but never had the time to sign their paperwork. And in those days, in order to hold your official position, you actually had to have a document, a certificate that was signed, was sealed, and that you basically carried with you as you went out to do your work to show that you had the authority that you claimed to have from the government. The old president had to leave. A number of these certificates never got signed, even though the people had been appointed. And after the election, Mr. Marbury, who had been appointed to, I believe, to be a notary, was seeking to have his commission papers so that he could begin to work, to collect his salary, to exercise his office. And Madison, who I believe was Secretary of State at that point, was in charge of the paperwork, refused to turn over the documents, and it ended up in court. It ended up before the Supreme Court, where the court basically had to decide, did this person actually have a position just short of the paperwork, and that the new government, the new president, could be ordered to sign the paperwork and send it over, or because the fact the paperwork was never signed and delivered, this person did not have a job. Well, that issue got lost in what Chief Justice Marshall did with the case. In this case, Chief Justice Marshall looked at the Constitution. He looked at the law that spoke about creating these positions and what they needed to have to function. And he spent a great deal of time not speaking about the case itself, but speaking about the idea that, oh, here we have an issue. And we have an issue where somebody has to tell, is the president acting correctly or not correctly? Is the president following the Constitution or not following the Constitution? Is the statute passed by Congress creating this position, is it valid or not? And the Constitution is silent on who would do this, who would make this decision. Well, Marshall said, gee, what do courts do? Courts decide disputes. Courts make decisions. Courts interpret the law. Who best to interpret the Constitution? Who best to tell the branches of government if they're correctly following it or not than the court, than the Supreme Court? And that became the real heart of this decision. Now, what Marshall had done without anything written in the Constitution about this, is he basically set the reality that we have today, where the Supreme Court takes the position that they have the power and the authority and the right to tell the other two branches of government when they're acting constitutionally or when they're not. And that whatever the Supreme Court decides, the other two branches are expected to sit down, be quiet, and follow. Again, that is not given in absolute writing anywhere in the Constitution, anywhere in the amendments thereto. But Marshall was a very shrewd person. He realized that in many respects the court was the weakest of the three branches, and he wanted to somehow put it on a more equal footing, and he did this. And of course, we have adopted, and had adopted at that time, the English rule of precedent, which says that once you hand down a case, once you make a decision, we must follow it going forward. We must go into the future and honor this and almost worship what our forefathers had done. And therefore, this idea that the Supreme Court has the right to tell the other two branches what to do when it comes to interpreting the Constitution was now baked into our law as a legal precedent. And again, as I said, it has very much come down to us in this day. If you think of the various issues that President Trump had, trying to deal with DACA, trying to deal with building the wall, the courts at all different points along the last 4 years have felt absolutely free to come in and say to the president, no, you can't do that. Oh, no, you can't do that. Or you can only do this by modifying this, and that. So even today, Marbury versus Madison is still operating. It is still good law. It is still precedent, and certainly is the basis for a large part of what the court does today in determining whether statutes or actions taken by Congress are valid, and in determining whether actions taken by the president or by the federal bureaucracy that works under him or her are valid. Again, was this a good thing or a bad thing? It is so much a part of our system today, it's very hard even for me, having studied these matters, to imagine how the system would work without it. Most Americans accept this as a status quo, that this is just the way the law is, this is the way it's always been, this is the way it has to be. But there are certain constitutional and legal scholars who argue that John Marshall grabbed a big chunk of power here that the court was not entitled to, and once he had it, the court has steadfastly held on to it for over 200 years, and did not then, and is not now about to let it go. So, as much as Marbury versus Madison is set in our law, it is a precedent, it is the way that things work. If you go back to the time before it existed, it was not obvious that this is what the Constitution intended. It was not obvious that this is how things would work out. The reality of it is that it makes our Supreme Court far more powerful than the courts in almost any other country in the world today. There are very few places where the legislature and or the executive branch of the governments have to submit to what the courts are telling them. And in fact, it's very much the other way around in most countries, particularly in terms of the legislature. Whatever the parliament or the Congress of a country passes, the courts are obligated to follow it to the letter and to not question it or to try and determine the appropriateness or correctness or wrongfulness of it. All right, the next case I'd like to talk about, we jump ahead quite a bit, is the case of Dred Scott versus Sandford. Comes down in 1857, and the issue here was that Dred Scott was a slave. He had been born a slave. He was owned by somebody, I believe he grew up in Alabama, although I'm not sure of that. And he came to be owned by a Southerner who was an officer in the military, the federal military. Now, this is before the Civil War, so Southerners were still part of the federal army. And this officer, as officers do even today, as his different assignments changed in the military, this officer moved around from place to place. And Dred Scott was really this officer's like personal servant, almost what we would think of as a butler today. He was not a field hand, he was not a worker outside, but he very much kept the house, kept the clothing, kept the uniforms in clear, and was a personal servant to this officer, and moved with him many times throughout the country into various places. Well, a couple of the places where they went were free states, because again, by this point, by 1857, almost all of the northern states, which is still part of the federal government and the military still operated there, they were abolitionist places. They had abolished slavery. Slavery was not legal in them. And this officer brought Dred Scott with him as he moved from military base to military base in the north in free states. And finally, he was either reassigned or he was leaving the army and moving back down south for good, and said to Dred Scott, "Oh, all right, we're going back to Alabama, or we're going back to Mississippi." At which point Dred Scott said, "No, sir, I am not. I have been living in a free state with you. There is no slavery in this state, so therefore how can I be a slave here? And you do not have the right to order me to go anywhere. And at this point in time, I am choosing to leave your service and to stay in this free state and not to return to one of the states where slavery is in effect and where I would for the rest of my life be your slave." This became a very hotly contested case. The equivalent of the GoFundMe pages of those days came into play, where different abolitionist organizations and wealthy people who were abolitionists and donated money to this cause hired lawyers for Dred Scott, gave money for him to live and argue this case through the state courts and the federal courts until it finally came to the Supreme Court. The Supreme Court, when it reached them, through the Chief Justice at the time, who was Roger Taney, did the most awful thing you could think of. Not only did they answer the case, they could have simply answered the case by saying yes, by bringing Dred Scott to a free state, he's free, or no, by bringing the man there, he's not free, he's still a slave, he must go back with you. They could have just answered that question yes or no, and they could have left it at that, and that would have been the end of the story. However, the Chief Justice was a Southerner, was very much pro-Southerner, was very much pro-slavery. He could not leave it at that. So in the case, he went on to say that the slaves, the people who had been brought to North America to be slaves, were not citizens. They were not members of the political body that made up America. And even once they became free people, freedmen as they called them in those days, they still, by virtue of their African ancestry, could not share in citizenship, the right to vote, or the civil rights of other Americans, because that was not the intent of what was supposed to happen with them when they were brought here, and the writing of the Constitution did nothing to change that. So not only did he enforce the injustice of saying that Dred Scott had to go back to the South and remain a slave the rest of his life, but he went so far as to say that slavery was perpetual, that these people who were slaves or whose ancestors had been slaves were not citizens, could never be citizens, could never have full rights, and were forever to be a subjected minority, whether they were free or slaves, and that was the law, and that was what it was going to be for all time. This case very much angered Northerners. It drove the abolitionists nearly rabid. Many historians look at this and say, if anything triggered the Civil War, it was this case and the reaction to it. The times had become very difficult. The country became very divided, with a large number of people in the South upholding slavery and wanting it to continue, and the majority of the people in the North no longer wanting it. Congress, trying to walk the path between the two sides, had done various things over the year, like refuse to allow any arguments about abolishing slavery to come before the Congress. They had something called the two-state rule, where if a free state were to come into the Union, then a slave state would have to come in, so it would keep the votes equal in the Senate, which means the South would not come to a point where they would lose the ability to control the federal government to such an extent that slavery could be constitutionally amended out of existence. That all was beginning to come to an end as we approach 1860. A couple of the other things that the federal Congress did, they passed the fugitive slave laws, which again very much echoed, or they preceded a little bit, but Taney echoed them in his decision in Dred Scott. The fugitive slave laws basically said that a person was living as a slave in a slave state. If they were to escape, just by virtue of getting over the border into a free state did not make them free. They were still the property of their owner in the southern state, and the southerner could get a court order and could order the federal marshals to go after these folks, even into the northern states, to capture them and bring them back. They made it a felony for northerners to assist these people in escaping. And if you've ever heard of the Underground Railroad, which is basically a series of safe houses going from the border in Pennsylvania and Ohio with the slave states into the north, and then helping people escape to Canada where slavery had already been abolished. It was a series of houses and barns and secret places and a number of people that would help to conduct the slaves from the slave states through the northern states, help them to elude and evade the federal marshals, and to hopefully get to the Canadian border where once they crossed, they could claim asylum and be free. If you know anything about the story of Harriet Tubman, she was a slave herself who escaped and then made a number of trips back to the South to help bring other slaves across the border to freedom and to connect them with the Underground Railroad. There are a number of houses and places in Rhode Island that were part of the Underground Railroad, and this became very sophisticated to the point where people had secret rooms, secret chambers. They had holes dug in the basements that they could cover with boards and dirt. Basements usually had dirt floors in those days, so that nobody would know that they were hiding people. And there was a great organized effort in the North to attempt to help people escape from slavery and then to conduct them out of the United States, because as long as they stayed in this country, they were not safe. This all came to a head in 1860. Abraham Lincoln was elected president as a Republican. One of the things you need to understand when you read and study American history is that what the positions of the two parties, the Democratic Party and the Republican Party, both existed by 1860. Their positions were somewhat radically different from what they are today. There have been dramatic changes in what the parties believe, who supports them, who their members are, as we've gone through the century and a half since that time. But in 1860, Abraham Lincoln, a Republican, ran on a platform that not one more inch of American territory would be handed over to slavery. This was a very critical issue because a number of years before, the United States and Mexico had engaged in a war, the result of which was that the vast area of land from Missouri going all the way over to California was ceded by the Mexican government to the United States of America and became American territory, waiting to be settled and waiting to be cut up into states. And there was tremendous issue, again, up until that point, with the land east of the Mississippi and adjacent to the Mississippi. Congress had maintained this balance of whenever they let in a free state, they would let in a slave state. Now you have this vast area of territory that is part of the Union, where people are beginning to move and settle, and they want to establish states, governments, and become states. The Southerners want the same system to continue, where half of this land will be given over to slavery and the other half get left free. And many Northerners began to complain about this. The abolitionists absolutely dug in their heels and said no. And the Republican Party came into being on the issue of being against slavery. And they weren't saying that we would abolish slavery in the South. They realized full well that it would take a war to do that. But they were digging their heels in. They were drawing the line in the sand and saying, we're done. We're not playing this game with you anymore. Slavery is an awful institution. It's horribly enough that it exists here. We're not letting it increase. We're not letting it grow. And so therefore, Lincoln said, should he be elected president, not one more inch of American territory would be turned over to slavery. The rest of it would be carved up into free states. And again, the Southerners knew full well that if it reached the point where there were a much larger number of free states than slave states, that the free states would vote to amend the Constitution. They would amend slavery out of existence. The Southerners would have no political say in it, and that would be the end of their system. The result was that the Southern states, a number of Southern states, seceded from the Union. They formed their own government called the Confederacy. They basically took the position that, hi, this has been nice, but we can take our basketball now and go home. We're done. It's not working. We want to have an amicable divorce. Abraham Lincoln's position on this was that once a state joined the Union, it was forever part of the Union. It did not have the right to leave or succeed, and that he would not recognize or admit that the states had succeeded. There was a stalemate for a while, as neither side really did much against the other than argue in newspapers, which were the means of communication at the time, and argue at political conventions that, well, we as Southerners have left, and you can't do anything, and Northerners saying, no, you can't leave, you don't have the right to leave. This kind of was a war of words until the governor of South Carolina decided that he would send his militia, what we would now call the National Guard, to take over Fort Sumter, which is a federal fort out on an island in the middle of Charleston Harbor. And Lincoln had been very clear in his orders to the military that they were not to abandon or give up any federal facility, any federal military base, any post office, anything they could hold on to in the South, that he did not recognize the split. They were not to abandon these positions. And to a great extent, a number of people in the military held firm. Many of the commanders, many of the captains, the generals were Northerners. And of course, and actually by this point, they were all Northerners because the Southern officers left to form the Southern Army and to basically try and set up a military for their states. And at Fort Sumter, the Civil War changed from being a war of words into a fighting war. As I said earlier, it was the bloodiest war we have ever fought. The southern states lost, and after that, a period called Reconstruction was set up, where a program was instituted to try and reintegrate the southern states into the Union. That was done with halting success and failures along the way. And again, the ramifications of this are still being felt today. The basic issues that are going on right now in Wisconsin, Minnesota, and Rochester of late, they are still an outgrowth of this issue of what do we do? How do we handle the fact that our system was developed from and for many years tolerated slavery based on your status determined by what race you were from, where your ancestors came from. All right, after the Civil War, the Congress had spent tons of money, hundreds of thousands of lives. They weren't in the mood to fool around with this. They enacted very quickly the 13th Amendment, which abolished slavery, made slavery forever, totally, permanently, completely illegal in the United States and in any territory that was ever to acquire in the future. And then somewhat later, a few years later, they enacted the 14th Amendment, which undid the other effects of Dred Scott. The 14th Amendment is very clear, and for the first time says, because the original Constitution was unclear on this, it for the first time says all citizens, all people of every state are also citizens of the United States of America, and that every state must provide equal protection of law and due process of law to every citizen. It also gave Congress the power to enforce these rules if Congress should choose to do so by legislation, by enacting statutes to make sure that these rules would be applied. This is a tremendous change. As a matter of fact, many people call this the second Constitution because now, for the first time, we have a clear statement that federal power and federal ability to protect people's individual rights comes before state power, trumps state power, and that the state governments are to be subjected to the federal government's view of what civil rights are and what the rights of citizens are and what type of justice and protection they should get. 15th Amendment was the last of these three, which we call the Civil War Amendments, and the Civil Rights Amendment guaranteed the right to vote to all citizens. Of course, at that point in time, it was only male citizens. It was only citizens over the age of 21. And in many states, it was only citizens who owned real estate, who owned property, that were given the right to vote. You would think that with these amendments, that tremendous changes would have come about very quickly, that the courts would have jumped on this and would have utilized these to protect the rights of the newly freed slaves and to exercise rights against various state governments that refuse to grant civil rights and refuse to deal with their citizens correctly. The court was not at all interested in this for the first 30 years or so. As a matter of fact, the only thing they really did with the 14th Amendment was, in a couple of cases in the 1890s, they used it to justify the legal concept that still exists today that says that corporations have the rights of individuals, that corporations, which are basically just entities created by state government for the purpose of running businesses and providing limited liability to the owners of those businesses, that these entities acquire certain civil rights and that they have the rights that individuals are guaranteed. In 1896, a case called Plessy v. Ferguson came before the court, which dealt with the idea of separate but equal. Louisiana's legislature had been retaken over by white pro-Southerners, anti-Northern, anti-black liberation or black equal rights folks, and they had passed a series of statutes saying that these races had to be separate in public accommodations. Plessy was a well-to-do black businessman. He bought a first-class ticket to take the train from New Orleans to Baton Rouge. And as he went to get on the train, this new statute had been passed a few weeks before. The conductor happily informed him that he must move to the third class car at the back of the train because he was not white. Plessy sued, claiming that this was a violation of his rights under the 14th Amendment, and the Supreme Court, at this point in time again, missed the ball completely. They came down with a decision that said separate but equal is fine. It is not a violation of due process. It is not a violation of equality. That as long as it is separate but equal, then the states have every right to separate the races, to make distinctions based upon racial criteria, and to enforce those against their citizens. Now, the problem with that is if you ask the sociologists and the economists, they will tell you that when you're dealing with majority versus minority, separate is never equal. By definition, it can't be equal because you have one group which is much larger, controls much more of the money and the power than the other group, and if you separate the two in society and make these artificial legal distinctions, there will not be equality. Unfortunately, Plessy versus Ferguson remained the law of the land almost up into the 1960s. Segregation became a part of Southern life. The states enacted something that were negatively called Jim Crow laws, which was this whole idea that whites and blacks had to be separate in school, separated in public accommodations. The blacks could not stay in the same hotels. They couldn't eat at the same restaurants. They could not drink from the same fountains. They could not sit in the same areas of public parks as whites. For those of you, most of you who are way younger than me, I am old enough to just barely remember the ends of this system. And it is unimaginable today how severely profound it was, how it affected all aspects of life, and how even in the North there were certain issues. There were segregated schools in Boston. There were not the same draconian regulations in the North, and many blacks in the 1920s and 30s moved to northern cities like Chicago and Cincinnati and Cleveland and New York because the laws were far less repressive there. But even in the North, to a certain extent, segregation was passed, and it was accepted as a way of life, as a way things were supposed to be. In the early 20th century, the Constitution was amended. The large issue then, capitalism had flourished, and thus the Industrial Revolution took off with the Civil War and continued through the 1870s, 80s, and 90s. The United States became highly industrialized, highly urbanized. The developments of railroads and then things like electricity and telephones and telegraph were changing society, and people were becoming fabulously wealthy. If you think of names like the Rockefellers, the Vanderbilts, who built those mansions in Newport, very much like today, a tremendous disparity between these rich entrepreneurs who made their wealth in oil and the railroads and the new technologies, very much like the people who have made their wealth with the coming of the computer and the internet, like Bill Gates and Bezos and Zuckerberg today. There was a growing movement in the 1890s, coming into the 19-teens and 20s, of popularism. And popularism was basically the idea that the government should get involved in controlling the economy, should put in certain regulations, should do things to ameliorate the issues of the poor and of the working class, and should actually take steps to bridge the tremendous gap between the wealthy and the poor. At this point in time, you had things like the income tax passed constitutionally, the women's right to vote was passed, prohibition was imposed. Prohibition prohibited the manufacture and sale of alcoholic beverages because many people felt that usage of alcohol, the drinking of alcohol, was one of the great pitfalls of the poorer classes and one of the things that held them back and prevented them from attaining their proper role in society and attaining wealth. And so there was a tremendous movement that was able to get enough votes in enough states and in Congress to amend the Constitution to make the drinking of alcohol illegal, more illegal than even drugs are today to a certain extent. Many of the things that we now take for granted, the Food and Drug Administration, the Interstate Commerce Commission, came to being during these periods as the federal government tried to deal with the idea of controlling the railroads that had taken over commerce and movement of people, to try and deal with the now manufacturing process of food, of providing food to the mass number of people that lived in the cities and no longer grew their own food, and to take over the whole idea of protecting people from fake and dangerous medicines that were being passed around and promulgated. In 1929, the stock market crashed. This is usually marked as the beginning of what was called the Great Depression. The Depression was to wend its way on until 1939 or 40, when World War II began and industries began revving up again to provide first war goods to the English and the French, and then as we got involved in the war in 1941 to support our war effort. But during that period from 1929 all the way through the decade of the 30s, the country was very much in the economic doldrums. Franklin Roosevelt was elected. Herbert Hoover, who had been the president during the stock market crash, was soundly defeated. And Roosevelt came in with a whole series of ideas to try and get the economy going. He instituted Social Security, the idea of providing pensions to older people who can no longer work. He attempted to create a whole series of governmental agencies that would provide jobs, make work for people. One of them was called the Works Progress Administration, that would use federal money to hire people to build, give money to the states to build courthouses, to build bridges, to build roads, to build parks, and anything you can think of on a state level just to get people employed, to put money in their pockets and get things moving again. And again, the Supreme Court looked at all these things and they used the 14th Amendment initially to strike down all of Roosevelt's ideas. And one by one, every different thing that Roosevelt tried to institute, the Supreme Court would take up a case dealing with it and would find that it violated the right to contract in the Constitution, violated people's equal protection and due process rights, or companies' due process rights under the 14th Amendment, and it attempted to strike these down until finally, in 1937, Roosevelt had had enough, and he promulgated the idea that he would create an additional number of justices. Now, one of the things in the checks and balances that are set up in the Constitution, one of the things that many people are not aware of is that while the Supreme Court is an independent branch of the government, the Congress has a great deal of say as to how it's constituted, and certainly all the lower federal courts exist at the pleasure of Congress. They need statutes enacted by Congress to maintain their existence. And the Supreme Court itself, the number of members that sit on it is clearly given to Congress to determine. If you have been listening closely to politics in the last 10 or 12 months, the idea has been floated. A couple of different candidates, particularly on the Democratic side of things, being frustrated with the fact that Mr. Trump was able to put two conservative justices on the court, and Justice Ginsburg at the moment is very ill. She is fighting tooth and nail to stay on the bench until she hopes a Democratic president will take office on January 20th and could appoint a more liberal justice. If for some reason, though, she passes away or she is unable to maintain that position, Donald Trump will be the first president in many, many years to actually get 3 judges put on the Supreme Court. In response to this, a number of legal scholars have come out with the idea that, well, Congress we should just increase the number of judges from 9 to 15 or to 21, and that way we can undo what Trump and the Republicans have done by putting conservatives on the court. Again, what was once comes again. What is old becomes new. Roosevelt, who was the first president to dramatically use radio during the Great Depression, one of the things he would do is on many Saturday nights, he would have something he called his fireside chat, where from the White House, he had a recording studio set up, and he would commandeer the airwaves, and he would go out and give a talk, speech very often. And Roosevelt had a very friendly, colloquial style. He almost sounded like your uncle or your grandfather sitting in the living room, just having a conversation with you, a fireside chat. He was very good, very effective at that, and he used the new, very famously, what's the word I want here? He used the new tool of radio, which had become extremely popular just as the internet took over things 20 years ago. As soon as radio became cheaply available and radio stations were set up, it swept the country, and almost every house, down to the poorest house, found some means to buy some form of radio and to listen to it for the news, for sports, for entertainment. And now we had the president giving us little chats, coming into our houses to talk to us. This is unheard of in history prior to this. Roosevelt actually floated the idea, one of his fireside chats, that he would increase the number of judges on the court to prevent the court from continuing to abolish and to find unconstitutional all these programs that he was trying to enact for the good and to assist the people. The judges of the court realized that this would forever diminish the power of the court, that once they allowed this to happen, the court would forever have to be subject to the power of the executive and or the Congress. And so lo and behold, miraculously, a couple of months after Roosevelt put forth this plan, and the Democratic Congress that was supporting he, also a Democrat, would have happily gone along with this plan, suddenly the court found Roosevelt's latest program constitutional. And lo and behold, a bunch of the other other programs were resurrected, run through Congress again, and one after another, the court said, oh yes, no, we misinterpreted it, or you changed it just enough now that it's fine. And I don't know that the judges really believed this or wanted it, but it's a clear case where, in order to prevent the idea from gaining hold that, well, when we don't like the judges, we can just add more judges, we can rearrange the number of judges, we can change the judges, they let go their older ideas about how the Constitution should be interpreted, and very much allowed much of what we now think of as a federal government. Many of the programs that exist, they allowed those to become law and to allow the federal government, and particularly the executive, to gain large amounts of power that it had never had prior to that point in time. World War II came about. And World War II ended the experiments in social progress. It ended the Great Depression because now we needed every able-bodied person, man, woman, and young person out working either in the fields or in the factories to make the products that we needed to fight the war and to keep our massive army going. At one point, the United States had 10 million people in the service. And that's in a country that only had 140 million, a third of the number of people that live in the country today, made up the population of the United States, and out of that, 10 million people were in the service, men and women. You cannot imagine the impact that had on society, nor can we imagine the amount of groceries and clothing and supplies, medical supplies, and not to mention the war equipment that was needed to keep this number of people moving and going and moving out into the world to fight all the way across the Pacific, into Japan and China and into Europe and into North Africa. It was an incredible endeavor, and it basically took the country out of the Great Depression, and it put the whole idea of the social justice ideas, the economic reforms on the back burner while we're fighting this war that many people believe was for our survival as a people, as a country. In the midst of the war, a tremendous issue arose. Once Japan attacked Pearl Harbor, the issue became, what do we do with Japanese citizens who live on the west coast of the United States, of which there were several 100,000? And there was great animosity. Racial animosity did not exist just between blacks and whites in the South. There was tremendous animosity in the western states against the Chinese and against the Japanese, who had come here in large numbers as immigrants in the first in the 1850s and 60s. The Chinese came to build the railroads, and then the Japanese came in later periods of time. And the Japanese in particular, and many of the Chinese too, were very successful business people, very successful merchants, had control of industries, factories, stores. They were very much part of the economic reality of the West Coast, but they were also stayed very much in their own societies, partly because of the racism against them, and partly because of their cultures and the language, great language differences between the Oriental languages and the Western languages. They were very much separate and apart from the white English-speaking population, and particularly because of the fact that many people viewed what happened at Pearl Harbor as a rather dastardly sneak attack, an unfair attack by the Japanese. The Japanese were very much looked down upon and very much feared. And there are very great questions as to how many of these people living with us are actually loyal to the Emperor of Japan and the government of Japan, and how many of them will be working against us, trying to get information back to Japan, basically working for the Japanese government. And because of that, very quickly, the federal government, the administration, the executive, along with the military, determined that they would treat every Japanese person in the United States, at least on the West Coast, as if they were an enemy combatant, and that did not matter if they were a citizen or they were a recent immigrant. They were all to be treated that way. The Japanese were rounded up on very short notice, and they were moved to Nevada and Arizona to internment camps in the desert, where many of them were forced to remain until the end of the war in 1945. The reality of this caused many of them to lose their homes, their businesses, their industries. It was a very, very, very nasty time, a very bitter time, particularly for some of the Japanese. They were third and fourth generation Americans at this point, and they were still rounded up and put into the internment camps. A man named Korematsu sued in federal court, seeking to be released from the camp, saying that this was unfair, that under the 14th Amendment, the federal government had no right to do this to him, a citizen of the United States. And in Korematsu versus the United States, the case came down in 1944 when the war was still going on, and the court just said, no, this is war. Governments have to do nasty things during war. Millions of people are being sent around the world to die, to fight for us. You can put up with being put in a camp for a few years. Really, what is your issue with this? The attitude and the decision of the court was very nasty, very much against the Japanese, and basically gave a rubber stamp to racial discrimination of the most blatant kind. The interesting thing, though, is that the judge who wrote there was a dissenting opinion. There were a couple of judges who dissented from the majority view, and the judge who wrote the dissenting opinion wrote a beautiful, scathing decision, or dissenting opinion, castigating in the official decision of the court, and basically stating all the ways in which the court was wrong, how it was misinterpreting the Constitution, was clearly misinterpreting the 13th, 14th, and 15th Amendments, and that it would come to rue the day that it ever handed down something like Korematsu, and that the case would come to be looked upon as the Dred Scott case of its era. Much of the judge's dissenting opinion 10 years later became the basis for the case of Brown versus the Board of Education, which was a Supreme Court case that came down in 1954. And in Brown, the parents of black students were suing the Board of Education, I believe it was in Kansas, in one of the counties that maintained segregated schools, and they were suing, claiming that segregation by the states was illegal and unconstitutional of the 14th Amendment and should be abolished, which would mean an overturning of the precedent of Plessy versus Ferguson, and the court went along with this idea in 1954. So from 1944 to 54, in the period of 10 years, you see this dramatic change where the court takes a 180-degree different position. Well, your instructor just realized dramatically that unlike in face-to-face classroom situations where I have a podium, with my little camcorder, which is tentatively stuck onto my screen on my computer. I cannot bang the table or bang the desk to make a point because the camcorder will not cooperate with that and went falling off to the computer down in the back of my desk. And I spent the last 5 minutes retrieving it and trying to set back up our beautiful state-of-the-art facilities here for recording and for communicating with you wonderful folks. All right. I believe I had been yelling and banging the table about Brown versus the Board of Education. Beginning with Brown versus the Board of Education, the Supreme Court embarked upon the adventure that most of us are familiar with and that most of us today don't even think twice about. It's become part of our lives in the last 70 years. Following Brown versus the Board of Education in 1963, they came down with Gideon versus Wainwright, whereby they applied the Sixth Amendment right to an attorney to the states and said that people accused of a crime, particularly of a crime where they could go to jail, must have an attorney. Even if they can't afford one, the state must give them one. And that just opened up the floodgates. And during the 60s and 70s and even up into the early 80s, there were a whole series of civil rights decisions, a whole series of criminal rights decisions handed down by the court, basically taking the Bill of Rights, using the 14th Amendment, and applying those rights to the state and federal governments in ways that had never been thought of or that had never been tried by the court previously, even though the 14th Amendment had existed for 90 or 100 years by that point. It took until that long a time for the court to really wake up and see it for the sword that it was, that they could use to enforce people's rights. The Vietnam War came along, and the Vietnam War brought tremendous changes to this country. One of the greatest issues in the war was the fact that, again, with World War II, people saw this World War II as a fight to the death, a fight for survival of the way of life of our country, of the political system of our country, of even the lives of our citizens. They watched some of the horrors that were perpetrated by the German and the Russian military, and they realized that were we not to fight this war, those horrors would be brought here and would be perpetrated upon our people, our children, our women, our mothers, our brothers and sisters. And there was this very much a sense of unanimity that no, we'll do anything and everything we can, even to the point of people giving up their lives to stop this from happening. Korea, which came about between the end of World War II and the Vietnam War, was not quite as clear. In Korea, we're fighting against communism, which had been the power in Russia and remained so during the war and after World War II, and extended its power to the countries of Eastern Europe after the war. And then the Chinese communists overtook China in the late 1940s, and we're moving into Korea and Vietnam. And in Korea, we're basically fighting to prevent the communists from taking over Korea. It was a little less clear whether that was in our interest or not, but we were toe-to-toe in a philosophical and ideological and social battle with the Soviet Union and the Chinese communists at that point in time. And there was still, I would say, enough of the spirit left from World War II that, and in fact, many people, interestingly enough, a number of the men who only were old enough to be drafted towards the end of World War II ended up being drafted again and sent to fight in Korea. But there was still this sense of we need to do this for our country, we'll do it. By the time the Vietnam War came into full bloom in the 60s, and the government needed to draft large numbers of young men to send them to fight in this country that most of them had never heard of and couldn't place on a map, it was much less clear what we were doing, and the sense we're now dealing with the children of the men and women who had fought in World War II. We're not dealing with these folks themselves. And it was much less clear, what are we doing here? How does this assist us? How does this help us? The war was badly mismanaged, badly handled, and the the anger against the war began to grow among young people. The resentment against the war began to grow. This was also the first war, interestingly enough, where television now existed. And again, just like radio, once television became cheaply available and they set up television stations, television spread like wildfire. And by the 1960s, even the poorest of houses had some type of television in the house where they could sit every night and watch. And with television had come the advent of the nightly news. At 6:30 every night, the three major networks would have their worldwide newscasts. And for the first time, people were not just getting their news from newspapers the next day or a few days later. They weren't hearing it on the radio. They were seeing it. And they were seeing it on their screens in their living rooms as they sat there at night watching, sometimes as they were eating their dinner watching. And for better or worse, the military allowed the reporters to follow the camera crews, to go in with the soldiers, to go in with the troops, to be in various of the areas in South Vietnam that were occupied by our military. And what began to roll back into people's living rooms were not pretty sights, were not happy sights. War is not a pretty business. It is a dirty, ugly, horrible business. And for the first time in history, this was being dumped into people's living rooms every night on a regular basis. Well, as this went on, the antipathy to the war grew and grew. The amendment, the constitutional amendment that lowered the voting age from 21 to 18 was a result of this resentment and the protests that were growing. Because one of the main arguments that young people were making, and there was tremendous agitation among college students, again, history repeats itself. There were demonstrations, there were the blocking of streets, there were the invasion of military bases, there were shutdowns of schools in protest by students. One of the main arguments in the early part of the war was that we cannot legally drink a beer or vote for our president, but yet we can be sent out to Vietnam to fight and die. And the vehemence of that argument became so great, grew so fast and so furiously that Congress proposed an amendment to the Constitution, and it was ratified in lightning speed to give 18-year-olds the right to vote. So at least then they had no argument that, oh, we're not even citizens, but you're sending us off to fight and die in a war that was voted for by old men and not by us. With the war came a tremendous argument of, what's the right word I want here? The media began to develop a tremendous amount of antipathy towards the government, towards the fighting of the war, and the media began to do all kinds of things to basically expose what the government and the military have been doing, anything that was bad, anything that they thought might be negative, and to delve into the secret things that have been going on, the behind the scenes things that have been going on. In 1971, the New York Times came into possession of basically what was a military internal history of the war, controlled by the Pentagon, held by the Pentagon, was supposedly top secret, but whistleblowers in the Pentagon leaked it to the New York Times. The New York Times went and said, we are going to print this. They called it the Pentagon Papers. President Nixon, who was president at the time, was still fighting the war, even though he had run on the position that he would end the war. He was still fighting it vehemently. And he did not want these documents to come out because many of them made the American military look not good in different things they had proposed and done. The New York Times said that they were going to print them. The federal government went to court to try and stop it, claiming that they were printing top secret material that was illegal for them to print. And the Supreme Court, in the case of New York Times versus the United States, came down with a ruling saying that as long as the material had gotten into the possession of the press, it didn't matter if it had gotten there illegally. It didn't matter if the people who had leaked it could go to jail for releasing classified information, that once the press had it, they could print it, and there was nothing the government could do to stop them. That was our pet creature you just saw walking across the back of the room there. Following hard on to this, again, the social cultural revolution was going on among young people. The sexual revolution had come into full vogue, and in 1973, the court took up the case of Roe v. Wade, which we'll deal with in much greater detail in a couple of weeks. But the basic idea here was that using this right of privacy that had been developing throughout the 1900s, Roe's lawyers made the claim that she, as a woman, wanted to go to her doctor to talk about having an abortion, which was basically a medical procedure. The state of Texas forbade her doctor to talk about it under the penalty of going to jail, forbade her to ask for one under the penalty of going to jail, and that this was a violation of her right to privacy. Such right did not exist as the word privacy anywhere in the Constitution, but that did not stop the lawyers from pulling together a number of court cases and using Justice Brandeis's theory about how we could recognize a right to privacy coming out of the common law. And they successfully argued to the court that regulations against abortion should be struck down as violating a woman's right to privacy, to make medical conditions in consultation with her doctor. The Supreme Court agreed with them, and the case of Roe v. Wade, that is still the issue of controversy and being contested today, and again, we'll study that in detail in a couple of weeks, was set down, again, bringing that idea of the right to privacy to the forefront. In 1974, the Congress had had enough of Richard Nixon. The Congress was controlled by Democrats. They were moving to impeach him. Again, things cycle around. And in the face of being impeached, President Nixon was stonewalling as much as he could. The basic issue here was that there was something called the Watergate break-in. The Watergate is a hotel and office complex south of the Capitol in Washington. At the time it was newly built. It was a very ritzy place, a place to be. The Democratic National Committee had their offices there, and a group of Cuban immigrants decided to break in one night and to invade the offices of the Democratic Party. Unfortunately, they were not professional criminals. They rather bungled it, and they were caught by a security guard of the complex who called the DC police, who promptly arrested them. And when they were about to be locked up, they said, "You can't arrest us. We're working for the Republican National Committee. They hired us to go break in." Lo and behold, it turned out that that was true. And then there began the furious attempt by the Democrats in Congress to determine how high up in the chain of command of the Republicans did this go. And they began to realize that it went right up into the White House. And if not to Nixon himself, it certainly went up to his closest aides and advisors, had concocted this illegal scheme to surreptitiously spy on it to the point of even breaking into and stealing the documents of the Democrats. Nixon did his best to stonewall and claimed executive privilege when the Congress, different congressional committees demanded that the executive branch turn over recordings. It was discovered that Richard Nixon, being the person that he was, somewhat megalomaniac person he was, it turned out that he recorded every single conversation that ever had gone on in the Oval Office for the years he was president. This was a secret system. Nobody knew about it, but in some depositions and in some other documents that the Congress had pried out of the executive branch, it was revealed that these tapes exist. Nixon refused to turn over the tapes. He claimed because of executive privilege, the Congress had no right to see them. And again, we're now in an absolute power struggle between two branches of the government, between the executive and the Congress. They end up in the court, and the Supreme Court here, in the case of the United States versus Nixon, ruled against the president and said that the tapes had to be turned over, they had to be given to Congress, and that criminality on the part of the president was not, possible criminality on the part of the president, his advisors, was not part of executive privilege, was not protected, and so therefore all this material had to be turned over. The result of that was Nixon ended up resigning just before they could impeach him, and the court again rose to power, decided in an issue between the two branches of government. It became the decision of the court that tipped the scale, so to speak, to use a legal idea, and turned over the power to the Congress. Now, the interesting thing is that Nixon didn't fight this. I mean, he could have barricaded himself in the White House with the Secret Service and say, "You're not coming in." And who are you going to get? The Army, of whom I'm the commander in chief, to break into the White House and get the tapes. But the respect for the court in those days was such that once they ruled against him, he knew it was over. And it was only a short time after that that he resigned in disgrace and left the White House, and Congress did not have to go through the business of impeaching him to try to get him out. Move ahead from 1974 to the year 2000. In the year 2000, tremendously hotly contested election between George Bush, the Republican, and Al Gore, the Democrat, who had been the vice president under Bill Clinton, who was just finishing his second term in office and so therefore could not run again. It came down to a very few electoral votes, and we will talk about in the next week electoral votes and how that all works. But it came down to just a very few electoral votes that separated Bush and Gore from winning the election, and it came down to the state of Florida. Every state fairly quickly counted and certified their electoral vote, their popular votes, certified their electoral votes, and so we very quickly, almost like the morning after the election, knew how every state was going, except in Florida, where there had been tremendous issues with people being able to get to the polls, with being able to cast their ballots, with trying to figure out if people's ballots were correctly cast or not, with people complaining that the types of ballots, and in many of the counties in Florida, they use a type of punch card system where basically you were given a cardboard card that you had to slip into a kind of metal plate, and then you had a pen, and you would stick holes in the card, and where you put the holes would determine who you voted for. It's very bizarre system, but it existed in a number of the larger counties in Florida, and people were complaining that they didn't know how to do it. Election officials were complaining that they didn't know how to read the votes, that the cards were so problematic that when you looked at them, it was very difficult to tell sometimes where the holes landed and who they were voting for. And they began a series of recounts in the different counties. Now, in most states, unlike Rhode Island, where in Massachusetts, where the cities and towns control the election process, in most states, the county governments control the election process. And they started counting and counting and counting, and as time went on, we got through all of November. Remember, the election is the first week in November. We got through all of November, and Florida was still counting. We got into December, and there were still counties counting, and it was getting incredibly close. At first, it looked like Bush had won Florida, possibly, but then the more that the voting went on, the more that Al Gore seemed to catch up, and it came right down to the middle of December. Florida was still counting. The Florida Supreme Court handed down a decision that basically said, let's do a recount for the whole state, which would have started the process over again and certainly kept it going. And we were quickly approaching January 20th, and we still had no idea who was supposed to be the president of the United States. In the whole history of the Republic, from 1789 to then, this had never happened. And with all of our technology, with all of our ability of computers and voting machines to count votes, to make elections go quickly and without problems, here we are with all of our power and technology being in the situation of we can't tell who the president's supposed to be. Somewhere along here, the Secretary of State of Florida, who was a Republican, had at one point certified Bush as the winner of the election. And that was part of her role. Part of her job in Florida was to get the election results, review them, and then to certify what she had received. And at some point when Bush was ahead, she had certified the election, and it was the Florida Supreme Court who basically, that was appealed to them, and they overturned her decision, said, no, let the counting resume and continue. It went up to the Supreme Court, and in Bush v. Gore, the Supreme Court basically said the voting is shut down. The certification the Florida Secretary of State had made several weeks previously was the final word, and that was not appealable, and therefore, basically, they gave the presidency to George Bush. When it came down, and we'll talk about this again next week when we talk about elections, it actually came down to this point in time. We don't really know exactly how many votes were cast, but in terms of the official votes, votes. It's within, I think, hundreds of votes difference. In a state with 25 million people, it came down to just a couple of hundred votes. And Florida has a large, because of its large population, has a large number of electoral votes. It was absolutely clear whoever took the electoral votes from Florida was going to be the next president, and that became George Bush. That decision has been hotly debated in the 20 years since then. Many legal scholars and legal authorities felt that the court interposed itself and it basically stole the election for Bush, and that it moved itself into the political process in a way it had never done before, and that it probably shouldn't. But again, that idea of respect of the Supreme Court still held. And I remember it was a very interesting time too, because for the first time ever, the Supreme Court does not allow recordings. It does not allow TV cameras into the courtroom, doesn't allow microphones into the courtroom, doesn't allow anybody to record the sessions. It never did, and that the only exception that they had ever made in that rule to that point was they knew the momentousness of this case, and it was broadcast over the radio. And I remember in between my classes that day and driving to and from my appointments, having the car radio on the entire time, listening to the Supreme Court justices ask questions of the lawyers, listening to the lawyers argue, listening to the judges argue among themselves, something that none of us had ever heard in our lives because it had never been done. But the result was the court interjected themselves into a popular election, and they basically picked the winner. It is disturbing to me that as we're rolling in a few weeks into the presidential election, that will be the 20th anniversary of Bush v. Gore, that we may find ourselves in a very similar situation again. Both sides, Republicans and Democrats, are already revving up on the news shows at night, complaining and talking about how, oh my God, we're going to argue this, we've got the lawyers, we'll challenge this, we'll challenge that. I am fearful that we may end up in that situation again. We'll get into December and not know who the president is. And I just am also fearful because the country is far more divided and the two sides are far less civil with each other than they were 20 years ago. In 2010, last case we're going to talk about right here. In 2010, the court heard a case called Citizens United versus the Federal Elections Commission. Congress over the years has passed a number of laws trying to keep large sums of money out of the political process on the idea that if people with tons of money can just dump it into elections, that they in effect are buying votes, they're buying the representatives, they're buying the president, and that they basically are taking power away from the people, and that it makes people's votes worth far more or less than they should be if this money weren't involved. Citizens United was a political action committee that was set up as a corporation to accept donations and to basically campaign and to put money into the election. They were fearful that the Federal Elections Commission would come down on them for what they were trying to do because based on some congressional laws and statutes, the Federal Elections Commission had been set up and had promulgated a whole bunch of rules basically saying corporations can't do this, can't do that, whatever. The case ended up before the Supreme Court. Citizens United had asked for a declaratory judgment from the lower federal court. A declaratory judgment is a situation where the party goes into court and says, I don't understand the law, I don't know how it applies to me, I don't want to go to jail, Your Honor, I don't want to have a civil fine imposed on me, please tell us what the law is so we'll know what we can or cannot do. The case worked its way through the district court, federal district court, up to the Supreme Court, and the Supreme Court basically, in making its decision, again, went back to the 1890s and basically said that corporations have certain rights of individuals, and one of them is a First Amendment right to publish their ideas, to publish their beliefs, to engage in political campaigns, and basically open the door to allow tons of money to come into political campaigns. And in the 10 years since that, that has certainly happened. The campaign budgets of all politicians on all levels, from the state governors and state officers up through the Congress and the president, the amounts of money that have are being spent now is just absolutely incredible compared to what it was only a few years ago. And corporations have a far wider range to get involved at this point than they had under the rules that were basically thrown out by the court. Again, many, many people, myself possibly among them, look at this decision as really being a vote by the court against democracy that basically is pitting the super wealthy people in this country and the super wealthy corporations against the average individual. And if we're trying, elections very much today depend on radio ads, internet ads, TV ads, being able to fly your candidates and their representatives all around the country to host various huge meetings that cost tons of money to rent facilities and to get set up. And that very often it's not one person, one vote. It's who has the most money to play the biggest games that comes out as the winner. And many people believe that Citizens United was not a good decision by the court and certainly plays into this whole idea that money can buy politics. All right, that's pretty much all I want to say about week 2. I will go on. Hopefully in a couple of days I will have the video for week 3 up and running, and we'll go on from there.